Hi friend, welcome to the Company Law Education and Appeal series. Today we are discussing Western Regional Director Order in the case of the SOC 5 Adam Suspension Private Limited for the violation of Section 203 of the Companies Act. In this case, SOC 5 Adam Suspension Private Limited is not appointed company secretary during the Corona lockdown period on vacation of the earlier company secretary. And Pune ROC issued so-called notice for explaining the non-appointment and after imposing penalty on the company, that is the maximum penalty imposed on the company and on all the directors, officer in default. Against this order, SOC 5 Adam Suspension Private Limited filed appeal to the regional director within the as 5 time period that is allowed as 60 days from the date of the receiving of the order in the prescribed form from ADJ having jurisdiction in the matter. Let's see the facts of the case. The appeal is filed by the appellant. The appellant have violated the provision of section 203 subsection 1 and subsection 4 of the Company Act. The company has not appointed the company secretary since 30th November 2019. ROC Pune has issued so-called notice to the company and its directors seeking information. Reply from the applicant received stating the previous company secretary has vacated the office. Further, company has to appoint a whole-time key managerial personnel within 6 months from the date of such vacancy, and after the vacation, the company initiated for finding suitable candidate. Due to the corona pandemic and lockdown situation, nobody was ready to come during those difficult times. After opening of lockdown, company started the initiative but could not find the suitable candidate. Further, company has not found suitable candidate and after finding suitable candidate, appointed a company's whole-time company secretary and requested not to impose penalty as non-compliance wasn't intentional and beyond the reach due to COVID-19 and without any malified intention. Further, as per the record maintained by the ROC, one of the directors were appointed on 18th December 2020. Therefore, penalty is imposed accordingly on the director also. The ROC imposed penalty on the company, that is the maximum penalty, that is a 5 lakh, and two director on 1,000 per day. That is the 3,53,000 on 2 director and 1 director appointed subsequently, that is the 1,51,000 for 102 days. In the appeal, the appellant has stated as under, the company has previously appointed a whole-time company secretary who was employed for more than 5 years and had vacated the office with effect from 29th November 2019. Due to COVID-19 pandemic, a strict lockdown was imposed on the entire country by the government of India and the company was unable to appoint a whole-time company secretary. Upon the unlocking of the lockdown, despite several work-related restrictions and limited staff, the company initiated the process to search for suitable candidate for the job of a company secretary in whole-time employment. However, fearing a spread of the infection of the virus, no candidate was willing to get employed. Additionally, the company being a loss-making unit, having eroded its net worth and the register office being situated at the outskirts of the city, the post of the CS in the company was not in an attraction option for the prospective company secretary to get employed, leading to further delay in employing of a company secretary. After conducting few interviews, the company could finally appoint company secretary in April 2021. The company being in loss since its formation, imposing such heavy penalty could put the company under acute financial stress. The adjudicating officer has considered even the period of the lockdown while computing the penalty on the company and its director. The appellant prays that appeal may kindly consider imposing minimum penalty to the company and its director prescribed under the relevant section of the Act. The forum provided hearing to the appellant through video conferencing through its authorized representative appear on the behalf of the appellant company and director in default. And RD carefully consider the impact order, all submission made by the appellant in appeal and oral submission made by the law representative of the company during the hearing. Accordingly, appeal is allowed. It was directed to the representative of the appellant company that the revise the penalty to be paid as under, that is the reducing the penalty 1/5 of the total penalty imposed by the Pune ROC, that is the from 5 lakh to 1 lakh, and from 3,53,000 reduced to 70,600 and 30,200 for one of the director appointed later on. Total penalty comes to 2,71,000 for the violation of this section. Pursuant to the said direction of this forum, the appellant company has submitted revised appeal and also submitted the copy of the challan payment receipt for the penalty paid to the MC, stated that as directed in the virtual hearing which was held, the total penalty 2,71,400 has been paid for the violation of this section by the company and officer in default through the challan. In view of the above, the penalty having been paid by the appellant company and officer in default, the appeal is disposed of accordingly. This is the order dated 1st February 2022 and published today, 3rd March 2022. Thank you so much for watching this update.